I want to briefly discuss what are the advantages and disadvantages of employment arbitrations that employers may want to consider before they implement arbitration agreements. Practical advantages include that it's a single plaintiff. In a single plaintiff litigation, it's less costly than a jury trial. The cost associated with extended jury trials, including time spent for preparing voir dire and drafting certain motions that are not heard in arbitrations, are time-consuming and costly. Also, there are jury instructions and exhibits and demonstrative evidence that have to be prepared that are costly in a jury trial that are not necessarily used in arbitrations. Also, unlike juries who may feel sympathetic to a plaintiff or antagonistic to an employer and award larger sums, including excessive punitive damages, arbitrators may be less inclined to allow personal biases and emotions to affect their award. In fact, arbitration awards consistently are smaller than jury awards in similar state and federal litigations. And most importantly, in employment cases, in a class action context, a class action waiver eliminates the significant litigation and settlement costs associated with defending class actions. As you know, class actions allow single plaintiff to bring a suit on behalf of many. The lack of a potential runaway jury or a large class also has the advantage of reducing settlement values significantly. In mediations and settlement discussions, plaintiffs' attorneys are unable to leverage the looming unpredictable jury potentially, and also they lose the leverage of having that collective class action motion that potentially will be filed and certifying the class as a leverage to get significant damages. So those are reduced in a, when you have a class action waiver in an arbitration agreement, the settlement value significantly goes down. Finally, arbitration agreements can protect the employer from unwanted publicity. As you know, arbitrations are confidential, unlike court hearings. Courts are inherently public forums. With few exceptions, docket filings are made available to any and all to view, and trials are conducted in open door to the public. So some employers may have reasonable concerns about litigating internal workplace disputes in a public trial. So by contrast, arbitrations involve private filings and closed-door hearings. So internal disputes are unlikely to become external exhibitions by media-savvy plaintiffs' attorneys. With that said, now what are some of the disadvantages of having an employment arbitration agreement? Although an arbitration is generally cheaper than a jury trial, arbitration costs have begun to get higher. In employment arbitration, employers must pay both the employer and employee's share of arbitration, the arbitration expenses and fees. In addition, the employers are responsible for their own attorney's fees and cost. Now you add that together with the cost of the arbitrator's fees and expenses, that can be significant. Hearing time fees charged by most arbitration providers these days can easily exceed $40,000 for a 3-day hearing. These are in addition to the employer's own attorney's fees and costs. There are also increased costs associated with moving to compel arbitration agreements if an employee is disputing that there is an enforceable arbitration agreement. There's added cost to move to compel it and defend against a challenge by an employee. So that's where a carefully worded arbitration agreement can reduce these costs and they can be eliminated. And finally, almost no appellate review, and to the extent there is any possibility of scope of a review, is very narrow.